Hello and welcome to Runkle to the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to cover the sentencing decision in the case of the Queen in Partington. Now, I've done a video on the trial decision, so if you haven't watched that, you may want to go check it out. I'll try to link it here. But just as a really brief recap, Mr. Partington was a police officer and he was found guilty of assault as a result of sort of a flying knee into the back of somebody who was being arrested. That person was being arrested after they were initially stopped for not having a bell. They'd given a fake name and then tried to run away from the police. And it was found that that use of force was unjustified, it wasn't warranted. And not only that, but the trial judge made some very strong findings of credibility, both against Mr. Partington and against his partner, basically stopping real short of saying words like lying, but not that short. So let's have a look at this. This is the sentencing decision in terms of what punishment Mr. Partington's going to face. So there's a lot here and we'll dive right in. All right, so reasons for sentence. I found Mr. Partington, a member of the Edmonton Police Service, guilty of assault in written reasons delivered on August 26, 2021. As mentioned, I covered those in a previous video. You may want to check that out before you check this out. After some procedural delays, counsel made their submissions to sentence on October 27, 2021. Their positions could not be further apart. Now, it's December 2nd, and this just came out today, so the judge took some time to think about the sentence in between there. This is a carefully reasoned decision here. Ms. McPhail, for the Crown, seeks a term of imprisonment between 60 and 90 days, so jail time. While she opposes a conditional sentence, if one is imposed, she says it should be longer than 90 days, as the cases make it clear that serving a custodial sentence in the community is less onerous than serving an actual term of imprisonment in an institution. So what they mean by a conditional sentence here would be if he's sentenced to house arrest. So this is considered jail time, but jail time that you serve at home, which is of course more comfortable than in a prison. So she's saying if you're going to do house arrest, it should be more house arrest than 90 days. Mr. Daniluk, who is the defense counsel here, seeks a conditional discharge for his client, or if a conviction is entered, at the most, or very most, a suspended sentence and probation. Since a conditional discharge would resolve most of the sentencing issues facing the court, I deal with that issue first. Now, a conditional discharge is a special sort of sentence. It puts you on a probation term, and then you don't get a conviction. It's not entered. It doesn't go on your criminal record. There's some procedural stuff in terms of how that happens, but essentially what Mr. Daniluk is seeking here is a sentence that would avoid a criminal record for this accused. So first, they're going to look at the appropriateness of a conditional discharge. So should Mr. Partington get a criminal record? Section 730 sub 1 of the Criminal Code sets out the preconditions which permit a court to impose an absolute or conditional discharge. Apart from some procedural prohibitions, they are two in number. A discharge must first be in the best interest of the accused, and in addition, it must not be contrary to the public interest. As has been noted in almost all the reported decisions, it will be a most exceptional case where a discharge would not be in the best interest of the accused. This is pretty much always the case. It's almost always the situation that it's going to be in your best interests that you not get a criminal record. And certainly that's going to be the case for Mr. Partington. So we don't even need to really look at that one. More difficult is the consideration of what would be contrary to the public interest. Although it was, now I should note here that to get a conditional discharge, it has to be not contrary to the public interest, which is different than in the public interest. You can see that little bit of distinction there. So not against the public interest is a little bit different than it being in favor of the public interest. That sort of middle ground essentially goes to the accused. Although it was delivered some 45 years ago, the Alberta Court of Appeal judgment in the Queen and McFarlane from 1976 remains the leading authority in this province on the application of the discharge section of the Criminal Code. So if you think that the criminal law moves real fast, we're still using 1976 law, and it's still good law. In fact, there's much older cases that we're still relying on. In that judgment, the court listed a number of factors which should be considered in determining whether a discharge is appropriate. As many of the decisions to which I've been referred, I will go over those factors which I think apply to this case. I should also note that the McFarlane list was never intended to be exhaustive, as the court itself indicated. And what they mean by exhaustive is that the factors, they list certain factors in McFarland as things that the court should consider, but that's not all they should consider. They can consider anything else that they think is relevant. So the court in McFarland stated, in consideration of the exercise of the discretion to grant an absolute or conditional discharge, we emphasize that it is quite impossible to lay down rules which would cover the myriad situations which may appear before a judge confronted with the task of appropriate sentence in any given case. We are of the opinion, however, that the following are some of the relevant factors which must be considered in every case. Note the sum of. Given defense counsel's position on sentence, I also bear in mind that McFarland's admonition at paragraph 12 that a discharge, conditional or absolute, should not be granted routinely. We think a discharge must not be treated as a substitute for probation and suspension of sentence. So when they say not to be, done routinely, there's got to be something that calls for it. It's got to be something not exceptional necessarily, but something that is, it shouldn't just be that everybody gets a discharge, is what the court was saying. The first of the conditions listed by the Court of Appeal is the seriousness of the offense before the court. The more serious the offense, the less frequent would a discharge be appropriate. And that makes sense, right? You think it makes more sense if somebody's going to get, is not going to end up with a criminal record as a result of it, if they shoplift, a slice of bread versus if they steal $10,000. Seriousness of the offense. So it would, for instance, be a most exceptional case when a crime involving violence would be dealt with by an order of discharge. So that's directly from McFarland at paragraph 15. The present case, by its very nature, involves violence. While the force applied did not result in an injury which amounted to bodily harm in law, from the video evidence presented at trial, it resulted in immediate, significant pain to the victim. Moreover, the force was applied without warning to a completely unsuspecting and unresisting person who was face down on the ground and for all intents and purposes under the control of another police officer. As Crown Counsel has pointed out, the manner in which and the place to which the force was applied clearly had with it the potential to cause bodily harm, which, fortunately for all, it did not in this instance. And, if you think about it, taking a flying knee and dropping into somebody's back, you could do some serious damage with that. You could crack somebody's ribs, all sorts of potential. All right, so finally, the surrounding circumstances revealed by the video make it clear that the actions taken by the defendant were completely unnecessary and that there were other alternatives far short of assault which could have been used to give the arresting officer whatever assistance he needed to handcuff the victim. In total, then, those facts strongly militate against a discharge. Militate, just sort of fancy legal language, but just means push us away from a discharge, is what they're saying here. The second, third, and fourth factors in McFarland have little relevance to the facts of this case. I have no evidence of the prevalence of assaults by police officers in this jurisdiction. There is no suggestion of any personal gain to the defendant by acting as he did, and this not being a property offense, the value of property does not apply. Now, in terms of this, I think it would have been open to the court to take judicial notice of the fact that the public has great concern about assaults by police officers and similar, but the court is not doing that here. And I can't fault the court. I might have done it differently. I might have asked the Crown to submit some evidence on that one, but we just don't have it. And the judge is not being improper here when they say, or when he says, I got no evidence, so I can't do anything with that. Defense counsel argued forcefully that I should consider his client's actions impulsive. That is relevant to the fifth factor in McFarland, explained by the court at paragraph 19 in these words. Fifthly, we think it is relevant to consider whether the crime was committed as a matter of impulse and in the face of unexpected opportunity, or whether it was calculated. So if you imagine somebody at a jewelry store and the jeweler turns their back for a moment, they say, oh, I've got to take a phone call, and they've left some valuable ring on the counter, and somebody who's not normally a thief reaches out and takes it and runs off. They were tempted by that opportunity. That's different than somebody who goes and they walk in with a careful plan to make this happen. They've got something to get through the glass and, a big planned operation. This is one of the factors that gets considered. I've considered counsel's arguments carefully against the evidence of the video, which I've now seen numerous times, and I'm unable to accept his suggestion that the defendant's actions were impulsive. The Oxford Dictionary defines impulsive as acting suddenly without thinking carefully about what happens because of what you're doing. What I saw in that video was a man taking 1 or 2 steps in a normal way toward 2 men, one of whom was lying silently face down on the ground, not resisting an officer who had his knee on the suspect's back and was holding his crossed hands. At that point, the defendant, without saying anything, literally launches himself with a knee into the suspect's back. The word that best describes what I saw is not impulsive, but deliberate. That word is defined in the same dictionary as done on purpose rather than by accident. So that's not a gentle finding here. That's the court sort of saying, no, this is not impulsive. This was a clear attack. So that submission by defense counsel was rejected. And I should note, Mr. Daniluk is excellent defense counsel. I've seen him in action on numerous occasions. It's clear that he's done good work here. It's just that this submission was not accepted by the court. So this is not, I'm not taking any shots at defense counsel here. He does excellent work, and this is just a tough case. This is a tough factual set of circumstances here. The final factor addressed by the court in McFarland is whether the commission of the offense should be a matter of public record. There's a strong argument that it should. Even if the defendant's employment as a police officer comes to an end because of this incident, there are other security-related positions available in the marketplace, and those potential employers should have access to this incident and its consequences in determining whether or not to employ him. And not just, other security positions. If we think about it, there's other police forces, right? And those other police forces might have been willing to hire him if not for the criminal record here. So I agree with the court here, and it makes sense. I emphasized above that McFarland did not intend to lay down an exhaustive list of factors a court might take into account in determining whether to grant a discharge. The public interest is not a static concept, so this is a broad and potentially evolving concept. Since McFarland was decided, the manner in which peace officers deal with the public, especially racialized minorities, has become an increasing issue of public interest. So what I said before about not taking notice of sort of public concerns about police violence, here there is some note about, concerns about whether the police are treating minorities fairly. In that vein, the Criminal Code has encoded as a principle of sentence, section 718 sub 2 sub a sub 3, which makes the fact that the offender in committing the offense abused a position of trust or authority in relation to the victim an aggravating circumstance. So that means makes it worse. All the cases agree that an offense committed by a police officer in the course of his or her duties is in fact breach of trust, and that denunciation and deterrence are the sentencing principles which must be emphasized in such cases. So denunciation as a sentencing principle, what does that mean? Well, it means that it's society condemning it, making a public show of saying, we don't approve of this, we dislike it, and we dislike it so much that here is the sentence that's going to apply. That's the principle of denunciation. Deterrence comes in 2 separate flavors. The first is specific deterrence, which means this particular person, this officer, this whoever it is, needs to be deterred and prevented from committing future offenses. So that's most applicable when you're talking about somebody who's a repeat offender, or where the crime itself suggests that it's likely to be repeated in some fashion. But there's also what's called general deterrence. And general deterrence means putting aside the person who's in front of the court, you also want to communicate to other people that they don't want to commit this offense because look at the punishment this guy got. You don't want that. So that's general deterrence. All right. In Alberta, the decision of Judge Rossborough in the Queen and Lapine, which has been quoted with approval in a number of subsequent cases, clearly set out the principles involved. For example, see the Queen and Savini, noting the special status enjoyed by police officers and the concurrent obligations they assume as a result, Judge Rossborough relied particularly on a decision of our Court of Appeal. Now, I think Judge Rossborough, and I may be wrong about this, but I think he's since retired, He actually taught my sentencing class when I was in law school, and I've appeared in front of him in a few instances. But it's just kind of worth noting that he's got several decisions that have sort of had legs, that have had a lot of impact. So this is an example of that when we see that he's being quoted with approval here. Uh, those enjoying this special status must be denounced when they abuse it. In the case of the Queen and Koopman, the Chief Justice of Alberta commented upon abuse of this special status in the following terms. Police officers enjoy a special status in our community. To the extent that they are the people on the front lines with whom the public has contact, they represent the justice system. For a police officer to breach that trust and engage in a violent criminal act, even though off duty, has consequences for the administration of justice which go beyond the actions of the officer on the one night. Put simply, it undermines public confidence in the police and in the end in the rule of law. And they note these sentiments have been widely endorsed, and they quote a bunch of cases. Finally, Judge Rossborough in Lapine sums up his conclusions in these words. For these reasons, the most important principles of sentence implicated in this case are denunciation of the offender's unlawful conduct, deterrence of other persons from committing offenses of this nature, and pronouncement of a sentence that constitutes an acknowledgement of the harm done to victims and the community by the offender's acts. I do not discount or consider irrelevant the remaining principles in the Criminal Code. However, it is my view that they are secondary to the three outlined above in cases where peace officers have assaulted prisoners. I note parenthetically that Parliament considers denunciation and deterrence to be the primary sentencing objectives for crime against peace officers committed by prisoners. I agree with those sentiments, and considering the factors I have discussed above, I have concluded that the granting of a discharge on the facts of this case would be contrary to the public interest. So what we have here is the judge has concluded a discharge would not be appropriate. So the only sentences that remain once that is eliminated are ones which Mr. Partington will end up with a criminal record. And the main reason for that, the reason that gets the most sort of airtime in this decision, is the fact that this is a peace officer committing this offense against somebody sort of in their care. Now, just kind of as an aside, I think that you'd probably have a poor time trying to get a discharge if you weren't a peace officer and you had similar circumstances. If you had somebody who's being held down on the ground by a friend of yours, and then you decided to, while they're already down on the ground, you decided to jump and throw a knee into their back. I don't know that you'd necessarily be looking at a discharge. I mean, you might be in a better situation than Mr. Partington was, but I think a discharge would probably be a pretty tough sell to the court in that circumstance. So, other sentencing factors. Notwithstanding that conclusion, there remain numerous sentencing options ranging from the suspended sentence alternatively sought by defense counsel to the term of imprisonment requested by Crown counsel. So you'll note that there's actually no overlap between the defense and the Crown positions. Sometimes you'll have like defense saying, I want 1 to 3 years in jail. That's our position. And the Crown will say something like, well, we want 2 to 5. And the court has this sort of overlapping ground. And when that happens, it's likely that the decision is going to fall into that overlap. But here, they're just so far apart, they can't be reconciled. There is no room to sort of to pick one that's within the range of both. So defense counsel is just asking for probation and with a suspended sentence. So what that means is you're on probation, and if you breach your probation, you can be charged with the breach of probation, but in theory, they can actually bring you back into court and say, listen, the probation wasn't appropriate because you can't follow it. And so instead, we're going to re-sentence you on the original charge. That's an option when you're on a suspended sentence. So in determining which of those options is most appropriate, there are both aggravating and mitigating factors to consider. So good things and bad things for the accused. One must also not forget that ultimately the sentence imposed must respect the fundamental principle of the sentence set out in Section 718, Sub 1 of the Criminal Code. A sentence must be proportionate to the gravity of the offense and the degree of responsibility of the offender. And there's going to be more on that later in terms of what this means. Now, this is not a huge decision, so I'm going through it in some detail. Well, I'll probably go through all of it just because it's a fairly meaty decision. There's not a lot of fat to cut out on this one, and it's a really important case, so let's continue. The most prominent of the aggravating factors is the breach of trust to which I've previously referred. While there may be different forms of breach of trust, a breach by a peace officer engaged in the execution of his duty is one of the most serious. The reason for this has been recently explained in some detail by DeLuca of the Ontario Superior Court of Justice in the case of the Queen and Theriault. And I'm probably mispronouncing this. I apologize. I'm terrible with pronunciation on names, but I try my best. Simply stated, the police are sworn and duty-bound to serve and protect all members of the community. In order to perform this function, the police are granted a great deal of trust and power. However, this trust and power gives rise to a corresponding duty to uphold the law and values of the community. When a police officer commits a criminal offense, he or she also breaches the community's trust. This generally means that the sentence imposed on a police officer will be more severe than that imposed on an ordinary person who commits the same crime. See the case of the Queen and Forcillo. Now, I just want to note here in terms of the breach of trust, and I'm going to give this as an example, and then I want you to, as we go through this case, think about whether the courts are actually applying these standards. Because here in Alberta, one of the principles that is often quoted in court is that theft from employer is a breach of trust that calls for a jail sentence. So if you have somebody and calls for a jail sentence unless there's some reason to deviate from that. So if you have somebody working at a gas station and they steal from the till, the assumption is going to be that that's going to be a jail sentence because that's a breach of trust. Now, there may be, circumstances where you deviate from that, but it is quite ordinary for the Crown to be seeking jail and for judges to grant jail in circumstances where you have these thefts from employers because of the breach of trust. Now, I would suggest that the breach of trust from a police officer is much more serious. As a society, we expect more of police officers than we do of gas station cashiers or people working at Walmart. A police officer swears an oath that they're going to uphold the law, that they're going to behave honorably. You don't swear an oath to work at Walmart or a gas station. So I think that this should be something that is in your head, something that you're just thinking about as we go through the rest of this. All right. In Alberta, the court expressed similar sentiments in the Queen and Lapine. There's another relatively recent amendment to the Criminal Code, which I should take into account. Section 718.04 reads, when a court imposes a sentence for an offense that involved the abuse of a person who is vulnerable because of personal circumstances, including because the person is Aboriginal and female, the court shall give primary consideration to the objectives of denunciation and deterrence of the conduct that forms the basis of the offense. Now, I should note that this provision is somewhat controversial because of how it divides things and whether or not the sentencing objectives that it accomplishes in practice are the ones that it proposes to set out. That's really a topic for another video, but notwithstanding the issues of Aboriginal and female, I think we can also get to vulnerable based because of personal circumstances, simply because there's somebody being arrested. Somebody who is in the course of being arrested and is coming into police custody is vulnerable in that circumstance. They're vulnerable as a result. So I don't know that we need to rely on that here, but the court is going to apply further analysis here. So they say, while it may be argued that the victim must be both Aboriginal and female for that section to apply, an interpretation with which I do not agree, although that is kind of the grammatical meaning there, but this looks like bad drafting, and I don't know that the court is improperly getting to what Parliament intended in terms of looking at the language here. It does remind sentencing courts of the increasing public concern about the interaction of the justice system with racialized minorities, which, in the prairie provinces especially, involves Aboriginal people to a great degree. So essentially, this is coming back to the issue of how are police relating and interacting with minorities, and are they doing so fairly? Mr. Hoole, the victim in this case, is Aboriginal with an all too familiar history of having been raised in foster care for most of his childhood. Now, I think the judge is treading on dangerous water with his language here, but carrying on. Among other things, that has resulted in a criminal record and his present incarceration pending trial on very serious charges unrelated to this case. Nonetheless, Crown Counsel emphasizes that he is one of those vulnerable persons whose welfare sections like Section 718 of Sub 04 is meant to address. In response, Mr. Daniluk asserts that there is nothing to suggest that Constable Partington had any idea that the suspect he and the arresting constable were dealing with was Aboriginal. There can be no doubt on the evidence that it is true, but that fact only takes us so far. It does rebut any suggestion that the crime itself was racially motivated, which in itself would be a major aggravating factor. Yeah, that's a big one. However, that does not end the matter. I must still consider what DeLuca in Theriault calls at paragraph 6, the broader impact of this crime, in the context of the community's present concern with the race relations involved in the interaction between the justice system and Aboriginal people. While that concept is not always easy to explain, the facts of this case offer some insight into the reality of the community's concern. In looking at the total picture of what happened that day, I wondered to myself how the average non-racialized Albertan would have reacted to Constable McCarger's attempts to deter bicycle bell crime. And bicycle bell crime in and of itself is a bit of an oxymoron because it's not a criminal offense to not have a bell on your bicycle. It's just a bylaw offense. Even if he or she was somewhat annoyed by what appeared to be a somewhat heavy-handed intrusion into a morning bike ride to enforce a rather minor contravention of a local bylaw, I expect most citizens would have identified themselves out of respect for the rule of law and the role peace officers have in enforcing it. If he or she were at all angered by his conduct, there might have been a later call to the commander of the local police office or to their local city councillor to complain about having been treated like a criminal when they were not really endangering anyone by their conduct. Now, I don't know if people actually call the local commander of the police office, and I don't know what that would accomplish. I will note parenthetically here that a Crown prosecutor, who I'm not going to name, but somebody who rides their bike fairly frequently, indicated that they have never been stopped to be, for a check to see if their bicycle bell was functioning or present, and that they had ridden both without a bike bell and without a helmet, and had in fact ridden past police officers without being stopped. That's in the same city here, and so, yeah, there is a distinction in terms of enforcement. Now, I'm going to clarify this. It's not entirely a race-based one, although race does play a factor in it. What ends up happening is that there's a fair range of offenses that really get prosecuted not so much for themselves, but for the opportunity they provide to police officers to conduct further investigation. What I mean by that is that you can stop somebody, you can do further investigation, and further, you can make them identify themselves now because there's a bylaw offense. You can possibly search them in some cases. So marijuana was a big example here, where the possession of marijuana back when that was an offense was not a serious offense. It was not one that anybody expected was going to result in serious time, but it provided a reason, a rationale that would allow police to search people. And so the concern that police would have in terms of possession of marijuana was really contingent on how much police thought you were a person that they might be interested in otherwise. Now, those sort of feelings end up being kind of related to hunches and stereotypes and various other things. So it ends up being connected to those elements. I'm not sure if I'm sort of explaining myself here all that clearly, but essentially, certain people are far more likely to get the police's interest as to whether or not they have a bike bell or not than others. And there's a whole host of factors as to what does that. So Mr. Houle, continuing on with the case here, Mr. Houle did not react that way. Instead, he gave a false name and then attempted to flee the scene. Why? There's no suggestion on the evidence that he feared that if he gave his real name, the officer would find outstanding arrest warrants, nor is there any evidence before me that there were such warrants. I think the answer may lie in the innate distrust many, if not most, Aboriginal people have in the treatment they can expect to receive from the police and the justice system in general. Mr. Hoole's victim impact statement attempts to express some of that frustration. Under the heading Fears for Security, he writes, "A overwhelming fear for anyone of an authority figure. It seems no matter how I put it, I cannot paint the picture or portray the level of fear for my or a loved one's safety I now have." Mr. Eagle Speaker, the maker of the video, and his father, Jason Grimm, who saw what was happening and was disgusted, are also Aboriginal people. There is no suggestion that either of them was anything but an ordinary citizen going about his business when their attention was drawn to what was happening in front of their home. Despite what they had observed and the evidence they had recorded of those events, Mr. Eagle Speaker testified that he didn't submit the videos to the police because he didn't want to get involved. That in itself says a great deal about the confidence Aboriginal people have in the willingness of police to deal fairly with their complaints. I note again, as I did in my earlier judgment, that the video came to the attention of the police not because of anything Mr. Eagle Speaker or his father did directly, but because he shared it with a friend and, as is not uncommon in the age of the internet, it eventually made its way onto social media. I'm also just going to note parenthetically here, I think that had he provided this directly to the police, the response would have been very different than what we see with it having made its way onto social media. This prosecution itself is potentially because there's public outcry on this one, and that the police, when they're given the opportunity to investigate themselves, seem to be far less likely to find that anything went wrong. Whereas the public sometimes will say, whoa, this is way wrong. And then the police are kind of dragged to that conclusion themselves after the fact. So continuing on with the decision, although I must still address the broader impact of this crime, I do not suggest that the process must be the determining factor in the sentence that is finally imposed. I do say that courts, if they want to maintain the respect of the public, must frankly confront unpleasant realities which come into play when, as in this case, Aboriginal people become the victims in criminal cases against police officers. Nonetheless, I emphasize what DeLuca did at paragraph 9 of his judgment at Theriault, which I quote, "My role in sentencing Mr. Theriault is also not to place solely on his shoulder the blame for the sorry history of violent interaction between members of the Black community and the police. While I must consider the broader racialized context within which this offense took place, I must be mindful of the need to punish Mr. Theriault only for the crime he committed and not punish him for crimes committed by others." Now let's have a little bit of consideration on that, because when we consider things about general deterrence, we also need to consider the role of that offense in the community. Sometimes we'll say that we need to start punishing offenders more harshly because a particular crime has become a major problem in the community. So there's a difference between punishing one officer for crimes committed by other officers, but there's also sort of an opening in terms of the law to say, listen, this is a problem. This is something we need to act on, and so we need to step up the punishments. So continuing on with the decision, Ms. McPhail points to a number of other aggravating factors. So again, factors that make the offense worse. Two of them have weight. Constable Partington did not identify himself when he arrived on scene, with the result that Mr. Hoole did not even know he was there when the blow came. This is not a case where a peace officer confronted with an uncooperative and aggressive suspect overreacts and responds with more force than is necessary. Rather, it involves the infliction of physical pain on an unresisting and unsuspecting victim. In addition, as I've already mentioned, it involved force which by its very nature the offender should have realized could have resulted in serious injury to the victim. So, I mean, there are words for what happens when you deliberately inflict physical pain on somebody in custody. There's a term for that, and the court's not going to use it. And I probably can't either, because I suspect YouTube might be annoyed at me. So carrying on, but you can fill in your own blanks there. Crown Counsel's last submission is more difficult. She asserts that his use of the words "shut up" after the assault and during the subsequent arrest of the victim shows a continuing animosity towards the latter after he was handcuffed. There was some disagreement between counsel about who actually said those words. Having listened to the recording a number of times, I confess that I'm unable to be sure who the speaker was. Ms. McPhail submits that I should be satisfied with Constable McCargar's evidence that the words were spoken by Partington. I am not, given that I've already made it clear that much of the constable's testimony was unpersuasive. Against that finding, I do not think this somewhat self-serving assertion should have any greater weight than the rest of his evidence, especially since the video makes it clear that virtually all of the post-handcuff verbal and other abuse of Mr. Hoole came from Mr. McCargar, not from the defendant. So what does this mean? Well, as I mentioned before in my sort of brief recap, the trial judge made very strong findings of credibility about the honesty of Constable McCargar. He didn't find him to be a terribly believable witness. And so having found him to be a garbage witness, he can't now say, listen, I'm going to rely on this garbage witness to justify making the conclusion that Constable Partington, the actual accused in this case, made that statement. And I think this is very fair. I can't find any fault with it. That's excellent reasoning. So turning now to mitigating factors, and I'll admit, I'm not super sympathetic to a police officer who has been found guilty of, abusing their status and using force against an accused that was unjustified, but I can't fault that reasoning. It's solid. So it might not go against sort of my general or might not go towards my general inclinations, but no, I think the judge would have made a mistake if he'd gone the other way. Turning now to mitigating factors, there do not appear to be many which can have much weight. Although defense counsel did not emphasize it, Constable Partington, not surprisingly given his employment, comes before the court without criminal record and with an impressive background which includes service with our military in Afghanistan. While that is important in many sentencing cases, it is less so where police officers are involved in offenses like this one. In that regard, I concur with Judge Rossborough and Lapine when he said, I'm mindful of the fact that the offender's previous good character, dedication, and hard work are likely the very attributes that resulted in his being hired as a police officer in the first place. The force of this mitigating factor is lessened in a manner analogous to that of the embezzler, whose good character enabled him to occupy his position of trust. I'm inclined to agree with the sentiment to that effect expressed by the court in the Queen and Langlaw. So what they're talking about here is, if you don't have a criminal record, and if you've got a history of being employed, of being a dedicated member of the community, that's always helpful on sentencing, right? You always prefer that to the alternative, where you've got somebody who's got a lengthy record and is sort of a known troublemaker. But where certain crimes are enabled simply because of that, and embezzling is one common one, because typically you don't get into a position where you can embezzle thousands of dollars or hundreds of thousands of dollars from your employer because you're a known thief. And so the essential legal principle there is that if your good character makes the crime itself possible, then it's going to have diminished weight in terms of reducing your sentence. So, and this is being applied to a police officer in this case. I'm told that it is likely that the defendant will lose his employment with the Edmonton Police Service as a result of this conviction, and it will also be fatal to his hopes of new employment with emergency services such as firefighting and emergency medical services. While I consider it unfortunate that it might have that effect on his attempts to find employment and in those related fields, the previous cases, including one of my own decided many years ago, Queen and Mand, have made it clear that the effect on employment of a conviction for a criminal offense is not a mitigating circumstance, but rather an inevitable possible side effect of that result. So it doesn't help him here. In a valiant effort to assist his client, Mr. Daniluk suggests that I should not use that consequence as a mitigating circumstance, but as part of the denunciation and deterrence required in cases like this. I'm unable to accept that submission, as it is to me simply an attempt to get to the same destination by a different route. Employers have the right to do what they do, but they should never feel that in exercising their discretion they become part of the deterrent aspect of the sentencing process. They make their decisions for the most part for unrelated business reasons, which should have no effect on the criminal process. Now, I don't know about the unrelated business reasons when we're talking about the police force. But yeah, and the judge here talking about it being a valiant effort is kind of throwing a little bit of shade on the argument. But I don't know. I mean, I think this is a clever way to try to get to it. It's just not successful here. Defense counsel also provided me with references to numerous reports of these proceedings in the media, suggesting thereby that I should take into account the effect on the defendant's personal life of the wide publicity given to his actions, both by members of the media and by the fact that the video itself is readily available on the internet to anyone who wants to take the trouble to look for it. So essentially, Mr. Partington is now subject to a whole lot of negative publicity. I kind of wonder if, I did a previous video on this. I wonder if that was included. I'm not going to call him and ask because, Mr. Daniluk is, as I mentioned before, a very good lawyer. And as a very good lawyer, if I called him up to say, hey, do you have a comment on, this case? Because I'm doing a video, I'm sure that his answer would have been, go away. That's the polite version of it. So, but you can see the argument here is that there is an impact on your life. It's, if you are, there's a greater public shaming sometimes that occurs because of video or because of these news reports than the simple criminal record would have gotten you anyway. And we can see that the impact of that might actually be greater. The criminal record might not prevent you from getting a job at all sorts of places that don't necessarily care about that or don't check. But being an unpopular person, being somebody who is the subject of public scorn, might actually prevent employment in a much wider range of things. It might make it hard to have a social life. It might make it all sorts of things. So I think there is some merit to this. I think it's a good argument. So for many of the reasons that employment issues are not mitigating factors, neither are publicity factors, with some exceptions. In my view, courts should be wary of allowing extraneous factors which are part of the everyday give and take of life to intrude into the sentencing arena. Media reports of the investigation and prosecution of criminal offenses fall into that category. While there may be exceptions to the usual rule, as conceded by Ms. McPhail, when false reporting of a prosecution causes inordinate and unnecessary damage and embarrassment to an offender, that is not the case here. Nothing in the material to which I have been referred suggests anything but a fair and factual reporting of the evidence presented at trial and the reasons given by the court in convicting the defendant. Again, I rely on the court in Lapine. Stigmatization through publicity can be taken into account as a mitigating factor when there's been significant publicity or the effect of that publicity on the offender is inordinate. In the case of the Queen and Deck, the court commented upon this in the following terms. Adverse publicity can be a mitigating factor when it fulfills a denunciatory fashion that has an inordinate impact on the offender. See the Queen in Hetherington. On the other hand, publicity is an ordinary incident of our justice system. Stigma for the offender is an inevitable feature of the criminal justice process. See the Queen in Martineau. In that light, it does not always justify a reduction in sentence. For these reasons, I conclude that media coverage of these events should not mitigate the imposition of an otherwise fair and appropriate sentence. Now, you might be wondering, where would this come up? What would be an example where this might apply? And I've been doing all of this Rittenhouse coverage, so it's an example that readily leaps to mind. Let us assume that the curfew charge, because Mr. Rittenhouse was charged and went to trial on, although it was ultimately tossed, a charge of breaching a curfew order. Let's imagine that that wasn't tossed and that the jury ultimately convicted him only on the curfew charge. Well, do you think the media would be reporting that, he was acquitted in terms of the violence? No, what they'd be reporting is, Rittenhouse found guilty would be, a headline you'd be seeing everywhere. And that would be an unfair kind of, coverage. Media coverage is not always fair. It's not always unbiased. It's not always presenting an accurate account of what happens in our court system. As a general rule, if you read about something that happens in the courts and you get real angry about it, there's a good chance that the media coverage is slanted to make you angry. That is a very common thing because if you're angry, you're more likely to click and, see the link. You're more likely to post it up online, and that helps their bottom line. So publicity can be a factor, but it's not here because the judge is essentially saying, listen, they're reporting on what you did. So that happens. Tough. So sentence. We've gone through all of the factors on what the judge is considering here. Let's see where the judge ultimately lands. So in determining what I believe is an appropriate sentence given all of the above considerations, I'm mindful again of section 718 sub 1 of the Criminal Code and the need to focus on the acts for which Constable Partington bears responsibility and not for the entire series of events described for me during the trial. While the broader impact of his crime on the community's justified concern about the interplay between Aboriginal people and the justice system is one consideration, it is only one. Looking again at Theriault, the judge explained that better than I do, is what Judge Ayotte in this case is saying. Sentencing is an exercise of balance anchored in the principle of proportionality. In arriving at a fit sentence, I must consider carefully the facts of the case as proven, including the aggravating and mitigating circumstances. I must also consider a variety of long-standing legal principles, some of which sit in conflict. Lastly, I must consider the available case law that establishes the range of sentences imposed for similar offenses committed in similar circumstances. Ultimately, I am required to punish Mr. Theriault in a manner that is fair and just. Sentencing is not an exercise in vengeance. My role is not to simply throw the book at Mr. Theriault because anything less will be seen as a slap on the wrist. Calls for the imposition of the maximum sentence, even where based on heartfelt sentiments, cannot be permitted to sway the outcome. Sentencing is not done by plebiscite, so not by vote. It is done by the reasoned and balanced application of legal principles to the facts of the case as I have found them. And honestly, I can get behind this 100% as a notion. The justice system is not about popularity. In fact, sometimes judges have to make unpopular decisions. And that's one reason why we don't have elected judges here in Canada, is that we really want our judges to be able to do the right thing, even, and in fact, especially where it's unpopular. In some ways, the justice system acts as a shield between, an accused person or a victimized person, either of those groups, and whether that's criminal or civil, and the public, in the sense that the public may call for a punishment that is, too harsh or too light based on sympathy or some other factors. And the role of the justice system is really to push past that and to decide based on principles of justice. That's the idea of it. And at its best, that's what our justice system does. Doesn't always live up to that, but that is the ideals that kind of drive us. And so I can get behind where they're going with this. So considering the totality of the aggravating circumstances addressed above, the mere entry of a conviction coupled with a suspended sentence and probation would not, in my view, reflect the degree of denunciation and deterrence required by the law on facts like these. However, this is not the Queen and Lapine, where the victim was assaulted more than once over a period of more than 2 minutes within the confines of a police detachment at a time when he was so totally incapacitated by the consumption of alcohol as to be literally incapable of defending himself or even to stand up without assistance. Those factors were clearly important in the decision to impose a conditional sentence of imprisonment, in that case, instead of a fine. So that was a case where somebody got house arrest with those facts. Think about that. I'm dealing with one and only one blow, which admittedly caused pain but no bodily harm. On the evidence I have, the defendant acted within the bounds of his authority after the handcuffs were attached, but not before. So if one reads the victim impact statement filed at the sentence hearing, I think it supports Mr. Danlock's position that it is directed more at Constable McCarger's actions than those of the defendant, who on the totality of the evidence played a secondary role in the entire incident. Had he not, and had there been more than one blow, a custodial term, either conditional or actual, would have been appropriate here. However, given the facts as I have found them, and applying the proportionality principles by which I am bound by section 718 sub 1 of the Criminal Code, I am satisfied that the denunciation and deterrence required by the offenses committed in these circumstances can be met by the entry of a criminal conviction and the imposition of a large fine. So accordingly, I convict the defendant of assault and impose a fine of $2,000 to be paid on terms to be determined after hearing from counsel. So what they mean by that is that the accused is likely to, they may have time to pay. So you don't necessarily have to pay that fine all at once. A fine is not intended to turn into a jail sentence. A fine, you're supposed to have time to pay it if you need time. And as a general rule, if you're making payments, at least here in Alberta, the court will typically be willing to grant you an extension, so long as it looks like you're making if you're making a real and actual effort to make payments. Where they're going to say, listen, sorry, that's going to turn into, a pay or stay warrant where you end up doing jail time instead, is where you either just blow it off and don't bother asking for an extension and haven't paid it in full, or where the court thinks that you're messing around. You've got a job that brings in $150,000 a year, and you've got this fine, and you've been making payments of $10 a month. The court's probably going to go, yeah, no, you could have paid that. Off you go. Now, in terms of this, I will note, this is a judge I'm familiar with. I've appeared in front of this judge before. He's very careful and fair, and I think that that's reflected in this decision. It's a very carefully articulated and carefully reasoned decision. I have trouble finding any faults with the logic of it. But where I differ from it is when I get back to my example of somebody who steals some money from the till working at Walmart or a gas station or something along those lines. Because the courts typically do not have much problem sentencing those people to jail and are, in fact, reluctant to impose a fine. So, we talk about the differing standard and the fact that police officers are to be held to a higher standard. In fact, one of the highest standards, if you think about it, when we think about what standard, the only sort of higher standards that the courts apply might be, for instance, to lawyers who typically, if a lawyer has committed an offense, that's viewed as very aggravating. Or if a judge were to commit an offense, although I'm not actually familiar with, there's probably cases out there, they're not leaping to mind. But police officers we hold as a very, high level of responsibility. Is this $2,000 fine really fitting with that? I'm going to be really curious. They're going to hear from counsel on this as to what the time frame is. I kind of suspect, and this isn't really a relevant consideration. I should note that this isn't a legal consideration. But I kind of suspect that they're going to say, listen, the time we need to pay this is right now. We're just going to go pay it. I suspect he's got the money. So, it's a large fine, sort of. You can get higher fines for some, bylaw offenses like driving without insurance. So, that's a provincial offense and it comes with a bigger fine. So is this really a huge fine? Is this really, accomplishing denunciation and deterrence? I don't know. I ultimately find this to be a little unsatisfying, and I wonder if the Crown is going to appeal it. The other consideration, and this is not mentioned in the decision, so this might be something that gets addressed when they talk about time to pay, is firearm prohibitions, because this is an assault. And so this triggers a discretionary firearm prohibition. And what I mean by discretionary is that it's not mandatory. The judge doesn't have to impose a firearms prohibition, but the judge does have to consider whether or not to impose one. And if the judge chooses not to impose one, has to provide reasons for why they're not doing so. So I'm going to be interested to see if Constable Partington ends up with a firearm ban at the end of all of this. I can't say that there are easy answers to any of this, but I am concerned that, we talk a really big game in terms of all of this. We say all this stuff in terms of, police officers are held to the highest standards. And what we see is maybe not so much living up to that when we actually come down to the decisions. I don't feel that this, as much as the judge says, listen, we're holding the officer to this high standard and so forth, I don't feel that the ultimate result really lands there. That's just my feeling. And I mean, at the end of the day, I wouldn't be super upset if we were, being more lax on the person who's, takes from the till at the gas station. But it's really inconsistent when we have this disparity in terms of expected sentences. That to me is something that it bothers me. I find it, an unfairness. So anyway, let me know in the comments below what you think, what you think of this decision. Personally, I think it's a really carefully reasoned one. I think that, while both sides might want to appeal it for different reasons, I think it might be tough to shake on appeal. That's my feeling. I don't think that the judge left a whole lot of openings for an appeal court to flip this one. Anyway, thank you for watching. I know this is a long one, but I've been waiting to see this one for a little bit, and it just came out today. I'm kind of excited. I'm a little tired, so hopefully everything made sense. I just came back from, well, I went out shooting. I was at Desert Brutality. I'm going to be making a video about that. It was a ton of fun. I was off in Utah, having fun, shooting guns, participating in a competitive shooting environment with a whole lot of people who are way better than me, which is in some ways the best way to be competing because that's how you learn. But so that was one thing. And then I went hunting and came back. So now I'm pretty tired. So hopefully that all made sense. I'm also likely to get that haircut that some of you have been agitating for in the comments for some time. It's getting to the point where it kind of gets tangled up in a rifle sling, and that's not good. When you sling a rifle on your shoulder and then you go, and pull your hair, that's not a fun circumstance. So this is probably going to go. I'll have to get that scheduled in. Anyway, thank you for watching. I want to thank my Patreon supporters. And again, if you like this video, please like it, share it with your friends, subscribe to see more content. At the $50 level, thank you to Jonathan Wheeler, Canada's National Firearms Association, Mike, Kyle Martin, Jean-Guy Toussaint, the CCFR, and the Canadian Shooting Sports Association. At the $30 level, Sights and Arms Limited and Marc-Olivier Demour. And at the $20 level, Raymond L. McKinnon, Peter Hilger, Matt Ward, Mark Whittington, Jane Babin Luxer, Dale Nesbitt, Cameron Johnson, Bruno R., and Andrew Elsich, and Aaron Del Salt. Thank you as well to the $10 supporters who will be in the crawl immediately following. And yeah, let me know. I've also got a few different things that I want to get done. I got to finish up Constable Senior because we've actually got a decision now as to the entrapment decision. So that's going to be something I got to cover. Part 2 of Ward. I still owe you guys a video on Kill or Kale, or I'm not sure exactly the correct pronunciation on that one, but I owe you guys a video on it. I also want to comment on the death of the gunsmith out in Ontario, which is a really tragic and messed up circumstance. There's a whole lot of questions I personally have, and some other things that I don't know that people have really considered yet in terms of that. So I want to do a video on that one. That one might be my next one, just because it's kind of a big deal. Anyway, thank you for watching. Hope that I've armed you with knowledge. See you next time.